Okay, welcome everyone. Excuse me, to the September 2018 edition of the HR Best Practices webinar series. My name is Mosher. I'm a partner at Thompson Co. Law Firm and MSBA certified specialist, basically HR attorney, certified specialist in labor and employment law, and manage the Minnesota office for Thompson Co. And I am happy to present to you today. So today we're going to talk about leaves of absence. And nationally, there's been a lot of movement in the last several years, mainly probably the last 5 years, to actually create some laws around requiring that employers provide time off. Now we're going to talk about more than just time off today. We're going to talk about all the different federal and, we'll have a splattering of other state type of laws, so leaves of absence that are under states as well as the federal government. So we're going to talk about more than just paid time off. But if you are new to the program, welcome. If you when you're registering, if you ask for HRCI insurance credits, then those will be the certificates will be provided after we confirm attendance and all of that after the webinar. And then if you do have any questions, you are welcome to type in the box, the question box. And as the webinar progresses, if I have time, I'll try to take a look at those questions. And if I don't get to them, I will circle back to you, and we can talk about it or exchange emails or something like that if there's a question. So, excuse me, I am sorry that my throat is a little clogged right now. Okay, hopefully that gets started. That would be all sorts of annoying, I suspect, on your end, listening to me. Okay, so we're going to talk about PTO, paid time off, which I had kind of started with. We're going to talk about the new stuff, which is sick and safety leave, and then we'll talk about family paid leave, which is a little bit different. It's different than FMLA. It's slightly different than sick and safety leave. And then we're going to jump in. So we're going to focus at the beginning on paid leaves of absence, and then we're going to transition into the unpaid leaves of absence, and then we'll, because no conversation can, webinar on this can go forward without talking about how those two things interact. Because, like I said, there's no federal law that requires that you pay people for time off of work, but there are a bunch of, company policies and state laws and city municipality laws that are popping up that are requiring it. So we have to kind of figure out between the policies and those other laws that require, we have to figure out when do I actually have to pay somebody, when don't I pay somebody during these unpaid leaves of absence. So that's the focus. Okay, so paid time off, PTO. Hopefully I all understand PTO. Okay, so like I mentioned, there is no federal law that requires that employers provide PTO. Later in the webinar, we'll talk about the most recent attempt that's got some bipartisan support at Congress, but not a whole lot. But a recent attempt to create a system where it's actually like paid family leave. But for the most part, if we just kind of step back at this and we look at paid time off, whether it's bereavement leave or vacation time or sick leave, though then there are exceptions to that. But for the most part, most employees, most people in the United States, employers are not required to provide some sort of paid time off. It's a matter of contract. And so when I think about paid time off, again, I call it PTO, but when I say PTO, I'm really talking about vacation leave as well as, any sorts of other paid leave that you provide to employees that aren't here at work. And most employers provide something, at least to full-time employees. And so, for the most part, it's a matter of contract. And so when I say that, I first of all, I'm talking about it in different terms, right? We're talking about vacation leave, we're talking about sick leave, we're talking about time off of work. And the reason we can talk about all those in different, because, one company might provide PTO, just generically PTO, and it can be used for anything. And they just say, take time off work. I don't care if you're sick or if you want to go on a vacation, or maybe they even throw bereavement leave in there. Go ahead, PTO. We're just, take it as you need it. Then some companies might have different buckets. So they'll have one bucket of vacation that can only be used for vacation. And then they might have one bucket for sick leave. It can only be used for sick leave. I remember having, this is a great story, right? Covering for my father when I was a kid long ago, and covering for my dad, and I was told, because he was like out hunting, so he would be out hunting in November, and if his employer called, I was supposed to say that he was too sick to come. I think the statute of limitations is run on this. I don't think they can claw back and go after him. Now 30, 40 years later. But the point was, that employer had different buckets. So they had vacation, and then they had sick leave. And my dad had used all of his sick leave, or didn't want to, or his vacation. He went on vacation, so he had used it by the end of November. Still wanted to go hunting, and so suddenly was sick. And in Wisconsin, when the Packers play on Monday night and you're working third shift, it's called green, gold, blue. So my dad was, it was a hunting endeavor. But the reason is because employers can create these different buckets. You can set the eligibility. You can determine, for the most part, with regard to PTO, you can determine who gets it. Do you get it after some sort of probationary period, 90 days? Is it only available to full-time employees? Then you get to define who full-time employees are. So there's, like I say, PTO is really a matter of creation. And so when we look at this, we need to have a policy. We create a policy. It has to be in writing. And a really good PTO policy is written, tightly, nicely. It talks about eligibility. It talks about situations, circumstances when it can be used. And then it contemplates potential abuse, because I don't know if anybody's ever experienced this, but employees are often trying to abuse time off work. I know it's a surprise. It surprised me too years and years ago when I first learned about it, but it is true. There are employees, I've heard, that try to abuse, I guess my dad's one of them, try to abuse their time off of work, their various things. So again, key points here are that it is a matter of contract between you and the employee. And I know a lot of people say like, oh, we don't have contracts with employees. That's not really entirely legally true. You have your employee handbook is an agreement. It's an agreement you can change, and you can unilaterally change it. You don't have to have buy-in from the employee. But PTO is the same. It is an agreement that you're setting. You're setting the conditions. You're setting the terms. You should have it in writing so that you can explain the terms and you don't get some sort of claim that you're owed PTO to an employee under circumstances that you didn't contemplate. Can you force employees to use PTO? And so we'll just jumping ahead a little bit. Let's just say somebody's on an unpaid leave of absence, like disability accommodation or FMLA or even military leave. Can you force? I'm sorry, take out the military leave. In FMLA, can you force an employee to use their PTO when they go off on FMLA, or if they go off on like ADA as an accommodation? And the answer is no, or yes. I'm sorry. The answer is yes. You can force them to use their PTO as long as you're not being discriminatory and you're treating everybody else on unpaid leaves of absence similarly. But you can say like use it or lose it. You need to use, before you start going on FMLA, you need to use concurrently with the FMLA. You need to use that PTO, and the reason is because you can again set the circumstances. You can set the criteria for this. There are some situations where you can't require California prohibits it, for example. All right, so let's switch over to sick and safety leave which is a newer concept in the last several years, and then parental leave, which is very similar, right? So with sick and safety leave, forward. So with sick and safety leave, we're talking about a paid leave, and this is where we're seeing a lot of movement at the state level. No real movement yet at the federal level, but at the state and municipal level, we are seeing a lot of movement on sick and safety leave. And so generally, and every one of these laws, what Austin's law looks very similar to Minneapolis's and St. Paul's and Chicago's and Sacramento's. There are a number of large cities in the United States that are requiring that employers provide some sort of paid time off that's accrued at normally about 1 hour of paid time off for every 30 hours of physical, like actual work, not just like paid time off, but actual work. And so the sick and safety leave, these employees they're able to normally start requiring it and requiring that employees start to earn it. So even if you don't have, like if you're in St. Paul and if you don't have a paid time off policy, and you just say, come into work because maybe you're not eligible. Maybe employers in St. Paul or Minneapolis don't want to give employees who only work 10 hours a week paid time off. Well, under these cities, in these cities, in Chicago's similar and stuff, in these cities, we're going to see that like even part-time employees are able to earn sick and safety leave. So paid time, some sort of paid time off. And so they even 10 hours work, even 15 hours work, they're going to earn that sort of paid time off. Now, what are the circumstances where we normally see this? There we go. You see that we're having some internet problems. Hopefully, it's not impacting the quality of the audio. But what are we seeing? So where are they? What are the examples of where the person is entitled to use it? So the cities require, these states require that employees are able to earn the sick and safety leave. So then the question is, like, what makes it sick and safety leave? Normally, it's situations that are very similar to FMLA on the serious health condition side of things. And so we're seeing sickness, like if it's a personal sickness, or if in these cities and states, if it's a personal sickness, or if it's a sickness of somebody in your immediate family, even including in-laws in a lot of cities and states, that you can use this time that you're accruing, this 1 hour for every 30 hours of work, or some states it's 1 hour for every 40 hours of work. But if you have a bank of that, then you can use it to take care of your sickness or the sickness of an immediate family member. Again, however the city or law is defined. Safety is a concept that Illinois first came up with a little over 10 years ago, probably about a dozen years ago, and that has started to catch on fire too now. And so we're talking about sick and safety leave. They're normally combined with these newer states and cities that are adopting these laws. And the safety is to handle abusive situations. So if it's normally some sort of like family abuse. So if somebody needs a restraining order and they have to go to court, they need to see a judge, they need to do a number of whatever it is to take care of an abusive household situation for themselves or for an immediate family member, then they can then go take time off. They can take this time off that they've accrued. So it's really important, like in all of these, St. Paul and Chicago and again Austin and Maryland and Minneapolis, lots of all over New York City. We really need to understand what the specific rules require. So if you have employees working in those municipalities, in those states, you need to take a look at that law. You need to understand the circumstances. What's the eligibility? Is it all employees? Is it some employees? What's the eligibility? What's the accrual? How is the person earning it? And then finally, what are the circumstances for use? What type of medical notes can I request? Some cities allow that you can ask for medical documentation to support the nature of the leave, so that you can confirm that your employee's not out hunting when they say that they're going to see a doctor, or that they say they're going to see their lawyer about a restraining order. You can ask for some documentation, but some of these cities are saying, like St. Paul, for example, they say that you can only do it after 3 days. And that only then can you ask for medical notes, unless it seems like there's some sort of abuse going on by the employee. So there are some limitations, but again, these limitations are going to be driven by the law itself. But just to know that, like, this is the trend. So sick and safety leave, there's so much effort and money and work right now by health professionals, health-related professionals around the United States, pushing for these laws to require that employers give sick and safety leave to their employees, because health professionals believe that employees, first of all, shouldn't come into work when they're sick, and then for their own personal health, but then also allowing people not to come into work, even though an incentive not to come into work when they're sick is really good for businesses and for the health and the population and everything, so that they don't spread the disease or sickness or whatever. Parental leave is slightly different, right? So whereas when we talk about sick and safety leave, we're talking about sickness, family member, or for the employee themselves. For the parental leave, we're talking about, again, paid time off, and we're talking about generally what it's looking like now is a few states have provided paid parental leave, and it's looking like an insurance program. So that's how California, New York, they've set up, Rhode Island's the most recent one, they've set up these insurance type of programs where the employer, I mean, right now there's a short-term, a lot of employers provide short-term disability insurance, right? But and it normally, it's not always covers, the mother's time off, at least some sort of percentage, and maybe it clicks after a couple of days, whatever it is, in terms of the policy, in terms of your insurance policy. But this one's mandating that employers pay money into a pool. Like New York also requires that employees pay into this pool. But what happens, so for example, in New York, what happens is that there's this big insurance pool that's just went into effect in 2018, and contributions started a little over a year ago, in 2017. And so they built up this insurance pool. And so what happens is now, if an employee wants to take time off to spend with their new baby, bonding leave, or adoption, replacement for foster care, then they can take the time off work, and they can apply for reimbursement from this insurance, from the insurance. They can apply for reimbursement of their wages, and the percentage of that reimbursement, I mean, it sounds like short-term disability insurance, right? But it's for mothers and fathers, any employee that's potentially impacted here with the trigger of a birth, adoption, foster placement. But in New York, for example, the percentage of the payout is going to increase for the next several years. So eventually you're going to get to, I can't remember if it's exactly 100% or very close to 100% of your full wages for that time off that you are going to take in New York by the time the law is fully implemented. So that's a situation where they created an insurance policy, and there's going to be a payout to those employees who are triggering the requirements of that. Different than a sick and safety leave, where it's accruing time off that's then provided by the employer. So insurance type of pool versus sick and safety, which looks more like your typical paid time off model, just limited to sickness and safety issues. Now you might be asking yourself, we'll jump into FMLA in a minute, but you might be asking, like, well, okay, how does that work with FMLA? And then there's a lot of mini FMLAs, like parental leave laws at the state level, and state-specific type of FMLAs. But there are so many of those out there that it's hard for me to deal with in this webinar. But looking at just the federal law itself, the FMLA, could it run concurrent? So for sure, bonding leave, right, post birth is going to trigger an FMLA requirement if entitlement for an eligible employee for an eligible employer. With the FMLA, would the FMLA run concurrent? The answer is yeah, you're going to run the FMLA concurrent even if, and that's unpaid, even if somebody's taking PTO, even if they're receiving pay under a sick and safety leave program, even if they're receiving pay under one of these insurance type of programs, you're going to still going to run the FMLA concurrent with that. We just look at the definition of FMLA and how that's met. So for what are the employees? Again, this is generally so. Just some more stuff along the lines of what I had talked about with that. The main takeaway point here is that you need to really understand if you have employees in these states that have parental leave requirements, paid parental leave. A lot of states have unpaid parental leave laws, and then there's the federal law as well that's unpaid parental leave. But with these states, we're talking about the paid ones. So you really need to just understand and look at each of those programs. What's the eligibility? Which employees are entitled to it? What type of paperwork can you request of them? Is this going to run concurrent with FMLA? And again, FMLA definitions are going to be different. It's going to be, you're going to look at the employer eligibility. Do they have 50 or more employees? And then you're going to look at the FMLA eligibility for the employee. Does the employee work within 50 or more employees within 75-mile radius of their job site? Did they work at least 1,250 hours in the last 12 months before going on the leave? Did they work for the company for at least a year? So we're going to look at that. We're going to look at employer eligibility. We're going to look at employee eligibility, and we're going to make a determination whether it runs concurrent, and it very well might, depending on the circumstances of either parental leave, which is more like bonding, or bonding leave under the FMLA, or sick and safety leave, which is more like a serious health condition. So I had mentioned earlier that there's a proposal at the federal level, and so that's the Ivanka Trump and Marco Rubio. They've kind of combined here. I think Rubio is basically pushing Ivanka Trump's ideas and plans, so he's kind of a spokesperson for it. And so what that would look like, and some news came out about that about a month, give or take a month ago, and what that would look like is rather than an insurance pool, which is what most of the states are moving toward for parental leave, and this is just for parental leave, right? So bonding leave for the baby, or adoption situation, or foster care. So what would it look like? We don't have a ton of detail. We have some speaking points on it, but basically it would be using the Social Security pool that an employee has built up through their contributions to Social Security. So we'd be dipping into that Social Security pool and delay. I think the way it would work would be to delay their benefits. This is the proposal anyway. I don't know. I don't think it's going very far, but it would delay their benefits. So, for example, I have children, 3 of them in fact, and if I were, under this Ivanka Trump, Marco Rubio proposal, if I wanted to take time off for the children, so they're born, and I want to spend, let's just say, 6 weeks with the most recent one. So I want to take 6 weeks off and to bond with the child, the baby. When I applied for Social Security, assuming there's actually Social Security around the time I get there, that's a whole other topic, right, for some other lawyers to talk about. If and when I applied for Social Security benefits, they would then look at my use, and I would get paid, I guess. I would get paid for the 6 weeks that I take off for this parental leave. I would get paid by Social Security, and then they would delay my benefits. So I don't really know enough about Social Security to know when I would be eligible for benefits. Let's just say when I'm 70 years old, and then I apply for Social Security benefits. They're going to look at my account and they're going to say, aha, back in 2018, you took out 6 weeks of parental leave, and therefore here's the hit to your account. You're going to receive delayed benefits. I don't know if it's going to be a 1-for-1 for like 6 weeks. It doesn't seem like much of a loss of benefit in Social Security, or maybe it'll be some sort of equivalent dollar amount. I don't know. I don't think the legislation is going very far. The Democrats don't seem to be all that much behind it. I don't think there's a ton of excitement by the Republicans for it either. But you never know. Times change. We have elections. Elections change things, and so a year from now, maybe it's a legitimate bill that's going through the Senate that we're talking about. I don't know. We'll see. But that's what's out there. That's the only viable proposal that seems to have some potential at bipartisan support at in Congress. The other alternative, which has been out there, but it's mainly pushed by the Democrats, and so it's not really getting a whole lot of traction, is basically what California does right now, which is to require employers to make contributions like they do to Social Security, like they do, or FICA generally, and then to make that into an insurance fund like California, like New York, into an insurance fund that insurance would then pay for the parental leave. So a couple ideas are out there. Again, I don't know with the climate and everything right now. I don't know how much traction. The alternative that California and New York have had, that's been out there longer, but again, it hasn't been going anywhere. And then the Ivanka Trump, Marco Rubio proposal is newer. We'll see what happens with that. Maybe it gets a tailwind after the elections or something, and we're talking about this paid parental leave in the future. Okay, ADA. So let's talk about ADA and FMLA. Again, both of these. So we've been talking about paid time off, and now we're going to shift over to unpaid time off. And again, there's going to be a lot of overlap with these. But just generally, I know this is kind of like 101, but what do we have with the ADA? For qualified employers, certain employers have to be a certain size. It prohibits discrimination against people with disabilities. Now, that's great. We probably all know about that. The key is that an employer has an obligation, under the ADA, an employer has an obligation to provide reasonable accommodations to address an employee's physical or mental limitations. But physical or mental limitations that somehow, some way, impact their ability to do the job. And so, if the limitation is impacting their ability to do one of the essential functions of the job, then it comes to you as an employer to explore accommodating that employee. So, typical example, they'll just take somebody has a degenerative back condition and it prohibits them from lifting 20 pounds. That person is a nurse, and nurses have to push and pull and lift 50 pounds or more all the time. It's absolutely required for the job. And so what do you do as a hospital or as a nursing care facility with this employee who now has this back problem and is limited to lifting 20 pounds? You don't just immediately fire them. You explore accommodations with them. Have the conversation. Get the medical information. Find out is this going to be forever? Is it going to be temporary? We have to have that conversation. So that's required under the ADA. Required that we have these conversations, that we explore and ultimately accommodate where it's reasonable, where it's not an undue hardship. There are limitations. It has to be reasonable. It cannot pose an undue hardship on the business or pose a safety risk to the employee themselves or coworkers or customers, patients, that sort of thing. Others. FMLA is different because FMLA is just time off. And a lot of times we have to just kind of step back from FMLA because a lot of times, people will call and they'll say, what do I do? Here's the situation. The person, they've been coming into work, but, they're not doing their job, and they were on FMLA for a while. They had this health condition, but they keep coming into work. And it's like, well, okay, step back. FMLA, it only is FMLA if the person's not working. And if you're accommodating that person, let's just call it light duty work. If you're giving that person light duty work because it's a work comp injury or you created light duty work for them, it's not FMLA. You can't count it as FMLA. FMLA gives you 12 work weeks per year, however you measure a year. It gives the employee, eligible employee, 12 work weeks of time off work. If they're working, if they're doing something from home, whatever, then it's not going to count toward that 12 weeks. Very different than ADA, which is more of an accommodate as the person's working, versus FMLA, which is just a time off. However, with the ADA, one of the key things here is that when we look at accommodations, it's one thing to accommodate somebody to help them so that they can push or pull. In my nurse situation, maybe it's very feasible for that hospital or nursing care facility to accommodate the person, even though they've got the bad back. They can't do more than 20 pounds, but there's a 50-pound lifting restriction. Maybe that person can somehow be accommodated. With the ADA, so that's the conversation that goes out. If you get to the point where, let's just say in that same example, where the employer says, you know what, there's absolutely no way you can do this job with that lifting restriction with your back, and so you get the medical information, and you find out. What do you want to find out? You want to find out the nature of the limitation. You want to find out what the limitations are, and then ideally the doctor opines or takes a look at what the job description is. But then the other big thing is you want to find out how long it's going to be. It's one thing if the doctor says this will be forever and ever. This nurse will not be able to lift more than 20 pounds. It might even go down. But that nurse is never going to be able to lift more than 20 pounds. That's one thing. Easier to say, look, we can't accommodate you. Look to open positions. You're welcome to apply for other open positions that we have. That's how you do that. If the doctor, however, says minor surgery, he's going to be down for the count for 6 weeks. And then he'll be back, and he should be able to do the 50 pounds. Let's just forget about FMLA. FMLA would cover it, right? Time off work, FMLA. Let's forget the FMLA. Let's just say we're a smaller employer, and we're only looking at the ADA. The employer there in that situation looks at it and says, okay, can't do the job for 6 weeks. We can't accommodate you. You can't do the job. We're not going to create light duty so you come in and sort Band-Aids. So the only accommodation we can have, and this has to be in the arsenal for all employers, is time off work. So time off work, a reasonable amount of time off work. And so in that situation, the company, hospital, nursing care facility, might go back to the employee and say, look, okay, we've looked at our business, we've looked at our operations, we've looked at everything, and yeah, we can accommodate you with time off for 6 weeks. That's reasonable. Maybe it's not for every business, but for this business, in my hypothetical, it is. And so if they say, we can accommodate you with time off work for 6 weeks, there it is, unpaid time off, that's an accommodation. ADA requires it where it's reasonable, not an undue hardship. And there it goes. The guy's got the job, comes back in 6 weeks and can do 50 pounds or more without a reasonable accommodation. So there it is, ADA, time off of work. These are this is how we look at an ADA situation without the FMLA. If the FMLA were involved and the guy were eligible, well, the FMLA would absolutely protect his ability to return to work after 6 weeks. Even if it's a hardship, slight hardship, difficult on the employer, the FMLA is going to protect that person's job for reinstatement. There are some very nuanced limitations to it, but for the most part, FMLA, that's where the FMLA is going to come in and protect the job. ADA is not going to necessarily protect the job, but the ADA would be looking to give would expect that and require that you give 6 weeks in my situation for time off of work. So what I just outlined there is the interactive process. We call it the interactive process. It's recommended. It's not required. A lot of plaintiffs, lawyers think it's a requirement by law. It is not. It's a best practice. So the interactive process is the method that we use when we're having this ADA conversation with somebody who's potentially disabled and covered by the ADA. And this is the process. We meet with them, we find out, we get more medical information. We can't talk to the doctor directly, ADA prohibits it. We can ask the employee to take information to the doctor and have the doctor respond. But we meet with them, we find out more, we find out about the limitations themselves, we find out about how long it could potentially last, and so then we're in a best position where we can make a determination as to whether or not we can accommodate the person, whether it's accommodating them in the workplace so that they can do the actual job. And the IDA does not require that you move the employee to another job. It just doesn't. You have to. The ADA requires that you try to accommodate them within their current job, not that you move them to another job. And so we try to accommodate them within their job. If that's not possible, then maybe time off is the accommodation, and it's unpaid time off. And so that's the conversation. That's how we go through the interactive process. If ultimately you find that you cannot reasonably accommodate them, or that there's an undue hardship, then best practice is to invite them to apply for any other open jobs that you have. You don't have to create a job for them. You don't have to give them preference on an open job. There's no seniority unless there's a union situation. You don't have to give them seniority or any sort of bumping or anything like that. They're just another applicant for the job. But ideally you mention to them other open jobs that they can apply for. That's just a best practice that of course juries like to see. So like I mentioned before, ADA requires that we provide reasonable accommodations, and one of the accommodations can be time off work, and it can absolutely, there's a chart I was going to I'll show in a second, but there's absolutely situations where the ADA might overlap with the FMLA, where the situations, where the circumstances regarding the serious health condition are also a part of the disability. And then the FMLA would protect for 12 weeks. So jumping the FMLA, and then we'll look at that chart again. One thing that we've seen for the last probably 10, 12 years is employers getting caught for doing what we call administrative terminations. And so what an administrative termination is when the employee comes off FMLA, right? So they go on their full 12 weeks, they've got a serious health condition, and then they can't return for one reason or another. Let's just say because of the health condition. So for example, let's just go back to let's return to my back situation. If in that situation, the surgery was such that the employee was going to be out of work for 20 weeks, and they're on FMLA, and so they get the first 12 weeks. We don't want to automatically fire them, right? So they get the 12 weeks. We're going to put them on FMLA. If they're eligible, there's serious health condition, there's going to be inpatient care. That's a back surgery is going to for sure, hit FMLA. So we're going to put them on FMLA. We're going to do all the paperwork. We're going to have, with the FMLA, we're going to have the Notice of Rights and Responsibilities. If you don't have this paperwork, please let me know. It's on the Department of Labor website. You can also go to that website or Google DOL FMLA forms. You just Google that. You should find the FMLA forms. And the FMLA forms you're going to, so what are you going to do? So the person comes to you, they say, well, in 30 days, because they always give 30 days notice, because I'm not worried about that. They give you 30 days notice and they say, well, I'm going to have back surgery, and I'm going to be gone for 20 weeks after the back surgery. So then what do? You give them the Notice of Rights and Responsibilities. You determine that they're eligible, right? So you're going to give them the Notice of Rights and Responsibilities, filling that form out. You're going to, at the same time, give them a medical certification form, which requires that within 15 days, the doctor provides information, signs off on it regarding the nature of the medical illness. So you're going to do those two forms. Then you're going to, because you always get it back timely, you're going to get that medical certification form back within the 15 days. And you're going to then be able to make a determination whether or not the person is going to meet the conditions for the FMLA. And then you're going to do the designation notice. And you're going to send that out to the employer. Okay, so you do all the paperwork. it gets to the back surgery. Back surgery goes fine. Person's on FMLA. Once they stop coming into work and they start missing work, you don't really have to have the ADA conversation at that point. They get their 12 weeks as a matter of law. Then, after the 12 weeks, the employee can't come back. So, we don't want to automatically fire that person. I mean, there might be some circumstances where you could fire them. But for the most part, we then want to engage in a conversation. We can do this in advance, too. But we want to engage in a conversation to understand whether or not we can reasonably accommodate that person. So they've gone through the 12 weeks and they still have 8 more weeks left. So that the FMLA is going to protect that job. But the ADA is not necessarily going to protect that job. So then we have to assess, can we, because the guy can't work, he can't do the essential functions, so he can't come back. So the only accommodation is time off work. And so then it comes down to the employer to figure out, okay, can I reasonably accommodate him for 8 weeks? At this point, 8 weeks of time off. And maybe the answer is yes, maybe the answer is no, but that's how we want to do these. We don't want to automatically fire somebody unless there's certain circumstances with it, and there are exceptions to this. But for the most part, we don't want to just automatically fire somebody when they can't come off FMLA if they, unless there are circumstances requiring that. There are a number of exceptions to that rule. But just to let you know, the EOC has been pretty hot on this for the last several years, expecting that employers engage in a conversation and regarding reasonable accommodations if that employee can't come back. If the employee says, "Look, I'm not sure if I can never come back," that's a totally different matter. That's one of the exceptions because you're not expected to indefinitely accommodate an employee. But again, best practice: have this conversation, figure out what the accommodation looks like. Here's how it looks in a chart format. The differences between ADA and FMLA. Covered employers, FMLA again triggered. The employee might be eligible under FMLA for time off because a serious health condition isn't the same as a quote disability under the ADA. But they've watered down what a disability is so much in the last 10 years that it's normally almost always if somebody's got a disability they're going to have a serious health condition, but not probably 100%. I'm sure there could be circumstances, but there is going to definitely be overlap in a lot of situations. But what is clear is that this is unpaid time off, and you could supplement it. You could force employees to take their time off if you have PTO, and again, that's a matter of contract. That's up to you. But we want to be consistent with it. We want that in our PTO policy. We also want it in our FMLA policy. That if they're taking time off, whether it's for the ADA or FMLA, then we want to articulate: do they have to use their paid time off that they've accrued? Do they have to use all of it or some of it? What is it? Again, you get to determine a lot of the criteria around this. And then how, moving on to work comp, how does work comp work with all of this? When work comp is an insurance type of product, assuming the person's eligible and getting paid and everything, how is work comp working with it as well? So a lot of times when somebody, if the injury is in the workplace, they're going to be off work and they might not be able to perform the job. The doctor might say, no, the person just can't work, or the person can work but here are the circumstances. Excuse me. So if they're off work, if they're not working, the person's probably going to also, assuming they're eligible and everything like that, the person's probably going to qualify for FMLA. And so FMLA protects the job. Work comp actually doesn't protect jobs. Work comp stops you from retaliating against an employee for being on work comp or for reporting a workplace injury. In that retaliation, that standard's pretty strong. It's pretty universal in most states. That you shouldn't retaliate against people for claiming work comp. But it doesn't actually say you have to return the person to work. That's the FMLA. If the person's concurrently on FMLA while they're on work comp, that's fine. They can get paid for work comp from the insurance. It's going to burn their FMLA, and I know there are some states that say that you can't concurrently do this, but for the most part, federally and in most states, you can do it. But yeah, most of these states, work comp actually doesn't protect the job. Work comp just allows for the time off, and then it pays the employee if they're off work because of a workplace injury. And that's why so many employers try to create light duty. And again, the ADA doesn't require that you create light duty, but work comp, it might be in your best interest as an employer to create a light duty job for the employee, so that they're not sitting at home eating Doritos and collecting those sweet work comp benefits. And instead, they're coming in and they're sorting Band-Aids or, answering phone calls or something like that. Things that they can do within their medical restrictions, even if it were a workplace injury. So, a lot of this is about juggling the difference between like paid time off, supplementing paid time off with these unpaid times off, whether it's ADA or FMLA. And actually, we'll talk about it in a second. The other thing, one of the things that you need to, that I didn't mention with your paid time off, is one of the things to address is how is somebody earning paid time off? Are they earning it, are they doing a drop-in program? Or they're just doing a lump sum drop-in, like say at the beginning of the year, where they get 2 weeks of PTO? Or are you doing it more on an accrual basis, where they're getting a certain amount every pay period, or a certain amount every month? Are you capping it? Are you capping the amount that somebody can accrue? Are you implementing a use it or lose it policy, where if they have the PTO, they have to use it up by the end of the year, or they lose it? Or maybe you allow some minimal amount of carryover. Again, these are all matters of contract. Well, one of the things in the policy that you want to address, at least in your FMLA policy, is what happens with FMLA time. Is the person still accruing PTO? If you have an accrual basis and they're accruing every pay period, or they're accruing every month, and the person's on FMLA for 12 weeks, do they continue to accrue? Are you paying, we haven't talked about holiday pay. Are you paying holidays to people under those circumstances? FMLA is unpaid time off. Do you have to pay holidays? No. The federal government doesn't require that employers provide paid holidays. That's entirely up to the employer. You could have no holidays. You could have no weekend work. You could have employees, except in some states that have one-day rest and 7 rules, like Illinois. You could, and California has limitations on this too, so it's obviously not universal, but you could literally have employees, have the office, the business open 7 days a week, and have employees work all 7 days. You have to pay for overtime, and then, of course, watch those states that limit that sort of thing. But the point is, you get to create, there's no federal standard. You get to create this. And so holiday pay, you might have it, you might not. You might not have any holidays. That's totally fine. Some employers might pay double time on Sunday for Sunday work. That's fine. That's entirely up to the employer. There's no federal law that requires it. I know California does in certain circumstances, but for the most part, that's quite the outlier. So anyway, one of the things is we need to figure out also do you continue to accrue benefits while you're on FMLA? And again, that's going to be up to you, or ADA when somebody's taking time off. Military leave, shifting over to another form of unpaid leave. It applies to all employers, and it protects the reinstatement for the. It does a number of things, but as far as the leave goes, it allows employees years and years and years of leave of absence. And when they get to go into active duty, and then when they come out of active duty, they then have to seek reemployment with you. And if they do, and they meet all the criteria, and they weren't discharged dishonorably or anything, then you have to bring them back. You have to bring them back into work, and also even potentially make good on some of the bonuses and wage increases if you did universal, like department-wide or company-wide wage increases to kind of make the service member whole. So military leave, again, unpaid, but and there's some, it basically protects the job, but you can find somebody else in the meantime to work the job. But like FMLA, when the person asks, seeks to come back, then you need to bring them back. So it protects the job, and it's another form of unpaid leave. And then that's also another triggering event for group medical. One of the rare exceptions to mid-year elections. I think I pretty much just covered that. I didn't say the exact 5 years, but it is a 5 years cumulative maximum for the amount of time that service members have before you can actually finally say, move on from them and not have to worry about it. So I guess there is. I didn't say 5 years. I just said 10 years. Okay, disability insurance. Disability insurance often runs concurrent with FMLA or parental leave. ADA as well. But the point here that I want to make with disability insurance is that it's an insurance and doesn't guarantee anything, at least with regard to reinstatement and guarantee that the person has a job. So a lot of times I hear from companies and they say, well, yeah, the employees on, their short-term disability insurance is about to run dry. What, because it's like a 12-week policy or something, what should I do then? And the answer is, well, the short-term disability insurance doesn't really protect the job in the first place. So you can actually, as an employer, if there's no FMLA and there's no ADA and just one of these situations where some sort of short-term disability, but it doesn't meet the definition of ADA or FMLA, and the person, you just look at that and there's no requirement that you hold the job open just because they do actually qualify for short or long-term disability insurance. So we want to differentiate. I want to make it clear that the insurance is just insurance. It's just paying some money. It makes it paid. It reimburses the employee for lost wages during the time that they're unable to work. But the insurance itself doesn't protect the job. It doesn't force reinstatement. It doesn't require the continuation of their group medical benefits even. FMLA does that. ADA doesn't. One of the nuances between FMLA and ADA. FMLA requires that you maintain the person on your group medical plan. ADA does not. So you might put somebody on a long-term. You might find it reasonable to accommodate somebody for 3 months leave of absence under the ADA, but you should probably COBRA at that point once they stop meeting eligibility requirements under your group medical plan. You wouldn't COBRA somebody who's still on FMLA because the FMLA extends their eligibility to continue within the group medical coverage. Miscellaneous leaves that often come up for employers. Right to vote. There is no federal time off to vote, I should say. Right to vote, time off to vote. There's no federal law that says employers need to pay employees to be off of work. A lot of states have laws that give employees. There's a couple different ways that these laws work. One type of law says that employers have to give the time off unpaid. So you have to give a reasonable amount of time off during the day, unpaid. And so a lot of employers will pay it, but again, that's up to the employer in those states. A lot of other states have systems that say, look, if you cannot vote during, if there's not at least 2 hours for you to vote at the polls, outside of the workday, then you can take up to 2 hours off during the workday, with or without pay, depending on the state, with or without pay, up to 2 hours off to go and vote during the workday. Other states, Minnesota is one of them, say, look, you can take the reasonable amount of time off, it's paid. You can take the reasonable amount of time off during the day to go and vote, it's paid. Jury duty, some states are different on this too. This is time off of work. For the most part, most states say that employers have to provide, can't interfere, can't retaliate against an employee for going on jury duty. But not all states say that it has to be paid. So again, if you want to pay for somebody to be on jury duty, that's up to you. Most states don't require it, but because as an employer you just say, hey, this is civic duty and everything, we're not going to hurt our employees in this situation. So then we're going to do paid jury duty. So that's fine. You can do that. You might pay for like 1 week of jury duty. You might pay for 2 weeks of jury duty. It's up to you. But jury duty is another type of time off that has some government protections involved, but most governments don't require that an employer pays. So it ends up being unpaid time off. You can make the employee use PTO, or you can allow them to use PTO if it's voluntary, if you want to, if you've got PTO for them. Bone marrow donations, nuance. Some states have this. Minnesota is one of them, where if you're going to go donate some bone marrow, you get some time off of work. Bereavement leave, normally, I'm not familiar with any states. There might be a situation out there of any states that require that employers provide paid time off for bereavement. If some employers will provide unpaid time offs. Most employers provide a couple days a year. That's normally my recommendation. Then you provide maybe 2 days per situation, maybe 4 or 5 days in aggregate over a year. But bereavement leave is pretty much, again, a matter of contract. It's up to you as an employer. There's no, I'm not familiar with any state, there's certainly nothing at the federal level that requires paid bereavement leave. So again, you're probably looking at your own policies, looking at how to craft them, and figuring out eligibility and the amount, all that sort of thing. About 10 or so states have school activity laws, and they're all over the board, like how much time. But for the most part, these states say, well, you get anywhere between 10 and 16 hours per year of sometimes paid, sometimes unpaid time off work to go to school conferences, to go to basketball games, that sort of thing. So every state, you got to look at each state individually, but that's another form of time off that we want to look at. And if it's unpaid time off, again, you could have your employee use their PTO. But again, there's about 10 or so states out there that have these laws that require that employers provide time off work for some form of school activity for their children or foster children, that sort of thing. Okay, I finished with 2 minutes left. I'm really excited about that. Thank you for your attendance this month. I'm really excited that we're going to have the next 2 months. We are going to have a how I hired a serial killer and then how I fired a serial killer topic. So I'm pretty excited about those. I see there were a lot of questions. We're up on time, so what I will end up doing is addressing those questions and sending them out to the group. If you have any other questions about the program, you're welcome to email me or to reach out to me by phone in our Thompson Coast St. Paul office. It's been my pleasure. I appreciate it, and I will see you next month for how I hired a serial killer. Thanks.